We have Beth Fellows on this as GAL. Are you folks present?
Yes, Your Honor. This is Beth, the GAL. I am present.
Okay. And then I see Ms. Shoemate. Where is Mr. Weiss? This is a large Zoom docket, so I'm just trying to find you on the screen. Okay. Well, maybe we'll give this just a few minutes, but I'll take care of one matter first, and then we'll come back to it. And Ms. Fellows, I did receive your motion in order for additional time. I have signed that, and I will file it with the clerk.
Thank you, Your Honor.
Thank you. We won't wait too terribly long because the other issue is a review of the ROI. So I'll wait and see if Mr. Weiss logs in here shortly.
Excuse me, Your Honor.
Yes.
This is Danya Emerson. I wanted to ask for a continuance so I can seek counsel.
Okay. So let's go to your case and see what we can do. Mr. Rooney, I see you there online. Heather Call is on this case, and actually, so I can't take this case yet. She's on another docket. So let me hear briefly, Ms. Emerson, how long of a continuance you're requesting for counsel?
I mean, even just 2 weeks. I've been trying to reach out to legal aids, calling all of the attorney offices that I can, just trying to see what I can do.
Okay. Yeah. Okay. Well, let's, I'm going to recall you. Like I said, Ms. Call did let me know she wouldn't be available for a little bit this morning. She's in a Clark County matter. So I'll recall your case when I see Ms. Call back.
Okay. Sounds great. Thank you.
Okay. Anyone else that believes they'll be asking for additional time? This matter. And I know this is a case we had some I see Mr. Entler. Is Ms. Entler on the line? Mr. Entler, if you're trying to speak to the court, we cannot hear you. You'll need to unmute. If you're on a phone, there you go.
Yes, I'm here, Your Honor.
Okay.
I don't know if Heidi's here today because she's been working quite a long hours, 18-hour shifts lately. She's been really busy.
Yeah.
So,
well,
we did come to an agreement where we wanted to reverse the parenting plan on Cadence and then keep it the way it was. So, and then the guardian ad litem, Amy, I do believe her name is, sent her a email of the parenting plan to get filled. So we didn't get that until sometime yesterday.
okay.
I think that the parties are in agreement that they would like to cooperate on a parenting plan and present that to the court.
And sorry, I didn't catch the very last thing you said.
Oh, that they would like to present that to the court for the court to sign.
Oh, okay. I wasn't sure if you said it had been presented to the court.
No, it has not. They're still working on it. I just learned that they'd like to do that a few days ago.
Got it. So let me ask, I guess, without Ms. Entler, I'm hesitant to full on strike a hearing. What case are you on for, sir?
I apologize for the interruption. It's
yeah, so these are fully done remotely.
I didn't know that. My phone.
Okay, right, sir. I'm telling you this. You are going to have to leave the courtroom. You can log on through your own device, or you can use an iPad that's out in the lobby. Okay. So originally this was just pretrial management. They have readiness on August 8th. And then the jury trial would be week of August 14th. Without hearing from Ms. Entler, I'm hesitant to do much of anything, but it sounds as if that trial may not be needed. Is that what I'm hearing?
Yes.
I think that's correct.
Okay. What I want to do then, do the parties, Mr. Entler, do you think that you And Ms. Entler would be able to get something together before your readiness date of August 8th, which is next Tuesday.
I'm not quite sure, but if we can get a little bit longer, it'd be great because I'm not sure what her new work schedule is right now. So she's been quite caught up into that and then working on school supplies and everything for the 3 children that are at home with her.
Well, here's the thing. Without the agreement of Ms. Entler, I can't strike the trial or the readiness.
Okay.
So what I could do, I can put you all back on this docket for review. Okay, here's what I'm gonna do. I really need Ms. Entler to be present. I'm gonna set this over 1 week to August 8th
Okay.
at 9 a.m. back on this docket.
At 9 a.m.?
9 a.m. But there's gonna be more times than that, so stick with me here, okay?
Okay. All right.
Okay. So I am continuing the pretrial management hearing to August 8th at 9 a.m. It is imperative that I have Ms. Entler here.
Yeah, I will give her a call today and let her know.
Okay, hold on. Let me finish. If she doesn't appear, essentially it'll be out of my hands and you'll be dealing with the trial judge on whether you're ready to go to trial or not.
Okay.
If she is here, we can talk about whether she's also requesting to strike the trial, which we could do if that's a joint agreement. And then go ahead, Ms. Looney.
I apologize. I just wanted to note that next Wednesday is the 9th. It would be the day after the readiness hearing is scheduled.
Thank you. You are correct. So actually, you guys are going to have to stick with your August 8th readiness.
Okay.
My guess is you'll just need to let the judge know that you're set on my docket for the next day to come up with perhaps an agreed parenting plan.
All
So
right.
you two can request to have the trial struck at readiness.
Okay.
Okay, so thank you, Ms. Looney. I really appreciate that. August 8 at 11:30 is your readiness where you both need to be there to let the court know how you're proceeding on the trial. And then we'll set you to this docket August 9th at 9 a.m. and we can review how close you are to presenting a proposed parenting plan.
Okay. So it's August 8th at 11:30 and then August 9th
At 9 a.m.
at 9 a.m. Okay.
And I need Ms. Entler present for both of those.
Okay.
Okay?
Yes, ma'am.
Okay. Ms. Looney, anything specific the state needs at this point in time?
No, Your Honor, we just need to know what the split for the children would be so we can calculate child support accurately.
Sounds good. All right. All right. Thank you.
All right. Thank you.
Anything else
Your
on
Honor.
this matter, Ms. Turnbull? Public
No,
iPad
that's
area?
all. Thank you.
Yes.
Okay, thank you. Okay, great. And then do I have Aaron Gilbert?
Yes.
Okay. And then I have Mr. Lawrence on this case. Good morning.
Morning.
All right, let me pull up your digital file. And I did get a draft order on this. What I understand is that this was placed on today's docket by Mr. Gilbert for an adequate cause determination. Respondent excuse me, Ms. Gilbert, you are requesting the change in the parenting plan, correct?
Well, so I guess this started, yes. I mean, this all started with a restraining order and then I guess a change in the parenting plan. So John hasn't had visitation until he completed what he has now completed.
Mm-hmm. And I'm just looking back at the prior judicial officers' orders that are in effect. So Mr. Gilbert, fill me in on why you have noted this up on today's docket. It looks like you're asking the court to deny adequate cause to change a parenting plan.
I want the parenting plan to stay exactly the same as it is. I want my visitation rights back. I did the drug evaluation. I did the hair test. I did everything came back negative. The evaluation, there's no recommendations, no nothing. I do not do drugs. I don't do any of that. I just want my visitation rights restored back exactly how they were.
So what I'm having trouble seeing, and I will acknowledge, especially given that your docket starts with the number 18, that you folks have been involved in this case for a very, very long time. You've had other judicial officers in this case. I am stepping in once many, many years have gone by. And I'll probably turn to Mr. Lawrence next. I think my concern is exactly what has been filed in front of me today appears to just be Mr. Gilbert asking me to find that there's no adequate cause to change a parenting plan, but I'm not really sure that's in my purview at the moment. So typically what would happen is the person wanting to change the parenting plan would file a motion asking for me to find adequate cause to do so, and then the opposing party would object. And it looks like we might be doing this a little bit in reverse. Mr. Lawrence, help me out here.
Yes, Your Honor. The action that we're currently in court for was the result of Ms. Winkles being supplied with, I believe, a Facebook post by Brenda Gilbert, and that is John's current wife. And she was alleging that John was using drugs, that they got involved in a domestic violence dispute. So this was supplied to Aaron, who became very concerned about what was going on when Max goes to visit. And so Aaron filed for a modification of the parenting plan. And the issue that the court was trying to deal with was to get Mr. Gilbert to undergo a substance abuse evaluation with the input of myself and Ms. Wilbanks. Mr. Gilbert contended that he had done that evaluation, but we had no proof of it. It was not filed with the court, and I had not received a copy of it, and I believe neither had Ms. Wilbanks. So we essentially put it on Mr. Gilbert's shoulders that if and when he completes the evaluation, then we would reschedule this matter and address it then. Mr. Gilbert did file that evaluation. It did indicate that they were not recommending treatment. And so that's pretty much where we're at right now. Ms. Wilbanks still has the motion to address, but it appears that the underlying fact pattern may not exist.
I see. And when, thank you for that. And when I go way, way back, I do see back in December of 2022, Ms. Gilbert had filed this adequate cause motion, and it looks like the judicial officer at that time essentially just kind of kept reserving on it pending the outcome of some of these evaluations. Does that sound correct?
Yes.
Okay. And then there was a restraining order put in place at one time. Is that also accurate? Temporary restraining order?
Yes.
Temporary.
Yeah.
If both parties agree just to go back to the normal visitations, can we just do that? I mean, all the evaluation paperwork, the drug test, the hair test, everything's came back negative.
So I was just served this or, got it in the mail over the weekend. So I did not have time to respond. I was considering asking for like a continuation just because all of this is done, but I have still heard that things are not going great at his house. They're still fighting. His wife just got a DUI. I mean, things are not going great over there still. So that's where I am.
Yeah.
I wanted to do a possible ask for more just so I could get maybe police records to see if any more action has been happening at their house for the last few months.
And when did you say you received this motion, ma'am?
Just in the mail over the weekend. I mean, I didn't get it until Sunday, but yeah.
Okay. Mr. Gilbert, when did you mail out this motion?
It should have been right after I got it, like on a Wednesday or so.
Okay.
Should have had it for a few days in our mailbox.
You think you mailed it this past Wednesday?
Like 2 weeks ago on Wednesday.
Oh, 2 weeks ago on Wednesday. Okay, well, she's telling me she got it this weekend. What I would like to do, I better understand the posture of this lengthy case. I think that we should actually set this for the show cause hearing. This will be both based on Ms. Gilbert's original December 2022 motion, where the judicial officer simply reserved ruling on many months. This will also include, sir, your motion to ask this court not to find adequate cause. I take at face value that Ms. Gilbert says she was just served this weekend. That wouldn't be adequate time to proceed today. What I'd like to present to the two of you is either 1 or 2 week, very short, set over. And at that time, we will do a show cause hearing where the two of you will testify. I'll take into account any written documents that you've submitted, and we will make the final ruling on whether there's adequate cause to move forward with changing the parenting plan or not.
So if we both agree, can we go back to the same old parenting plan?
If you both were in agreement just to strike the adequate cause motion, yes.
Okay.
So what we have outstanding is an adequate cause motion and an adequate cause motion objection. If the two of you were striking that, then yes, we would not be making changes to the parenting plan.
All right.
Okay.
I strike it, but
How?
I would like it too.
Say that again.
I would like to strike it down or whatever, but I also want to spend time with my kid this summer too.
Yeah. Would ma'am, would 1 week be enough time to next Wednesday? Would that be enough time for you?
Yeah, I think so. I mean, I have to request the records and I don't think you get them back right away, but a week I think should be okay.
Okay. So let's go ahead and go to the show cause on the adequate cause motion. And I'm dating that motion all the way back to December of 2022. And Mr. Lawrence, are you available on next Wednesday at 9 a.m.?
Yes, Your Honor.
Okay. All right. So I'll see you back both just in 1 week, and we will have that show cause hearing. I will make a determination. What I have in front of me is a motion for contempt. And it looks like it was filed by you, Mr. Smiley.
Yeah.
So let me turn it over to you. And what are you asking the court for?
Yes, I am asking the court to uphold Taylor to her agreement that she made with me.
Did you present any orders to the court? Or just your motion?
I did.
Say that again.
I just have the order to go to court to show cause.
Okay, just the order to show cause. Okay. So in looking at that, the motion that you filed, you are alleging child support payments of $50 per month was ordered back in July of 2022, and that she was also supposed to pay for daycare, education, etc. And I think your allegation is she has not paid daycare or child support since February 18th of 2023.
Yes, that is correct. She paid me a chunk from her taxes as essentially a back pay for not paying for the previous year. And then going forward from February 18th, I've not received a payment for either.
Okay.
I did bring cause and I listed out how much per week I was paying for each of us. And then how much, essentially I charged her a late fee like the daycare would do to avoid late payments, which she agreed to. And moving forward, it still didn't stop the occurrences of late happening. So I tallied it all up and then listed it out to show cause. But so I do have proof of that.
Is that something that you have filed?
No, I brought it with me today. I do have a copy for you, a copy for her and myself, and I can file it as well today.
Yeah, I don't have that in front of me. I also don't have any proposed order on this case. Let me ask Ms. Smiley, what can you tell me about, let's first talk about the $50 a month since February of 2023.
I had inconsistent work due to pregnancy, and I was not able to find a consistent job. Back when I did have it was when I sent him that money in February. And since then, I just had my baby. So I'm working on getting a job right now. But for the time being, I am kind of childcare until we figure that out with a job. But he's correct. I have not paid since February due to inconsistent income.
Okay. And when did you have your child, your most recent child?
5/21/23.
Okay. And then non-payment from February to May before you had kiddo, were you working in that time frame?
No, unfortunately, I wasn't.
Okay. Were you, I don't want to get into too many details, but were you laid off? Was there a layoff of the company? What exactly were the circumstances?
Yeah, I was working at Five Guys, and I was getting upwards of 30 hours a week there. I got COVID. I let them know I have COVID. I'm going to do the 5 days of quarantine. I let them know on the 4th day of quarantine that the next day would be my last day. I went in the following day after my 5th day of quarantine, so on day 6, and they had somebody to replace all of my hours, even though I communicated with my managers. And then the following week after that, I only had 9 hours, and they laid me off.
Okay. So, just looking at the support piece first, are you close to being able to start getting, being current on that and making some payments on the back benefits, or where are you at?
So Jasper and I both reside in Thurston County. So I did call and set up $50 child support payments in Thurston County about a week ago, maybe 2 weeks ago. So I did set those up. I haven't made my first payment yet, but I am working on that. I just had a job interview yesterday and I'm hoping to get it, but I'll find out tomorrow.
Okay. And then the child care expenses, looks like that's about $53.20 bi-weekly. And then I have a note that on June 21, that started to become $118.20 bi-weekly.
Yeah, that is correct. And then it switched to $300 a week due to loss of discounts, I guess you would say.
Okay.
But since I actually filed this portion, I ended up losing my daycare. Our daughter doesn't have a classroom anymore because she graduated up to the kindergarten room. So since Taylor is not working, we worked out an agreement where while I work, she watches her. So we've null and voided that piece, at least currently, until our school.
It's just maybe there's still some maybe past due child expenses owed to you, but not current.
Past due, just not current.
Okay. Here's what I'm inclined to do in a case like this, where I think there's been some employment downturn through no fault of Ms. Taylor or Ms. Smiley's doing, obviously taking into account that she had a child in May. You know, we want to give her some grace here, but still hold her accountable to what the agreement and the judicial order is. So I'd like to give you all 30 days. We would just continue this contempt hearing for 30 days. I would like to see some significant payments towards that $50 a month retro that you owe Ms. Smiley. And if you're making some significant efforts towards that, I'll deny the contempt. But if we come back in 30 days and you've done nothing, I can take, do you need me? Hold on one sec. It's not often that we would have a petitioner and a respondent want to share an iPad booth. So I think the entire court was like, wait a second, is everyone okay with this? So at least thank you for being civil enough to share an iPad booth. But I think, so coming back in 30 days, I just want to see some documentation, Ms. Smiley, that you are making some efforts to get that back bill paid and that you're staying current on the $50 a month, especially without childcare being a thing right now. If I see some significant efforts, again, I'll for now deny the motion for contempt. Sir, that doesn't mean you couldn't bring a new motion if things go south again. But I will approve the contempt order if, you know, we just really haven't had any payments. Okay.
You got it.
Okay. So let's put you all back on a date that'll work for you. It doesn't need to be anything, you know, real. It doesn't have to be exactly 30 days, but I would be looking, I would start looking Wednesday, September 6th at 9 a.m.
Okay.
Would that work for you all?
Yes.
Okay. So we'll continue the contempt matter to September 6th at 9 a.m. And then Mr. Smiley, if you think that, you know, you've started receiving some money and you're getting pretty close and you want to strike that hearing date before September 6th, that's in your prerogative to do so. But if it still needs judicial involvement, we'll keep that as a placeholder. Mr. Weiss, I see you there. You'll probably need to unmute and turn your camera on.
I'm present.
There you go. I hear you. And Ms. Shoemate, can you hear the court?
Yes.
Okay. So I had this on essentially for a quick matter to follow up on the ROI issue and where we are at.
I have gotten all three of them, and I emailed and mailed them to Kyle, and I emailed them to Beth.
Okay. Have you received those, Mr. Weiss or Ms. Fellows?
Yes, I did. I received them about 6:30 via email on Monday.
Okay. Does it look like we have what we need now? Are there any of those that we have to go back to the drawing board on?
It looks like they are appropriate, but I don't know. Excuse me, we won't know for sure. Mr. Weiss actually utilizes them to try to get the information.
Okay. Mr. Weiss, is that accurate to you?
I have not received anything yet in my email or the mail at all.
Sounds like it's on its way. And based on what Ms. Fellows is telling me, my plan, especially since we've got you guys on, you know, moving towards trial setting now, and we actually are moving forward. I'm going to, excuse me. I am going to not move forward with any sort of contempt on the ROIs, but I believe, correct me if I'm wrong, that we have a review date already set for September 13.
Yes, that was to review the updated GAL report.
So what I'll just add to that list, or well, let the parties know, if certainly you could re-note sooner if there's an issue with the ROIs that you need court involvement on. Otherwise, I'll make a note to check in with the parties at that review hearing to see if there's any tweaks we need to make to the ROIs, okay?
Okay.
Okay, that's all I had on my list. You guys are on universal trial assignment today, or excuse me, next week, August 9th at 1 o'clock. And that's the date where you all will log in and let them know how many days of trial you're anticipating needing.
Okay.
Yes.
So just to be clear, August 9th is not your trial date. It's Ashley Fleischman present. There's no one in the courtroom. We don't have anyone in a Zoom waiting room. I'm not seeing Ms. Fleischman online. There's someone with a phone number ending in 9667. Can you let the court know who you are?
Yes, Your Honor. My name's Patrick Ryan.
Okay. Okay, so the only unknown number is also not Ms. Fleischman. In pulling up your case, my understanding from reviewing the history when you were with a prior judicial officer is that this was set as a review date to check in on visitation. And I think there had been some bench orders issued at that time allowing supervised visitation between you, Mr. Smith, and then allowing public event visitation, allowing for video visits to continue, and then we placed it on for today just for review. I don't have Ms. Fleischman here, so there's not a lot I can do. I don't think I have Ms. Day here either, who's the guardian ad litem.
If I could,
Yeah, I'll let you tell me, where you're at, but I probably am just going to have to give you all a new court date when everyone's present.
understand. But as far as visits go, me and Mrs. Fleischman, my son's mother, we have had a complete turnaround in communication and co-parent. My son's at my house now. He's sleeping right now at my house. I have him almost every other day, probably. He's there with the weekend. Me and Ashley have really come to understanding with each other. There was a lot of resentments from her because I went to federal prison, but we've been working through those. I've been going to counseling and she's seen a counselor, and we've been doing things so we can co-parent together because it's, about my son. So,
Okay.
But everything's going really well right now.
That sounds great. So it sounds like you all are going to need the court to enter some orders that more accurately reflect kind of the agreed parenting that you're doing. So let me just go back a little bit further. You, like some other cases, I know you all have been involved in this matter for years and years. And I'm just getting acquainted with it. I'm just looking to see what parenting plan we're actually working off of. Did you all enter any sort of final parenting, or temporary parenting plan?
So Mrs. Fleischman filed one in 2019 when I was incarcerated. And I wasn't released until 2021. And then I filed mine, obviously, and then we, the judge put whatever together, and we've been going off that since last year.
Yeah, I think the last one I have.
I've only filled out one, so.
I was going to say the last one I have, although I'm not seeing that it was signed by a judge as a proposed parenting plan. Let me just go back a little further. Hold on.
I had overnight visits and everything, but with the lady that I was seeing at the time, we split up and it was kind of a really messy breakup. I missed court, and I also work at NORPAC at the mill. So I work rotating 12-hour shifts, and I missed another one because I got up at 6 a.m. after working 12 hours and I fell asleep. So the judge, that's why he's put it back to, supervised visits, kind of just
Yeah, you guys don't have much in place except for a series of bench orders kind of addressing visitation. So what I'm going to recommend, and it sounds like you and Ms. Fleischman are on good speaking terms now.
Speak every day. I mean, I take my son, I work nights. So my son comes over and hangs out at my house, while she goes to work, and then she'll pick him up and then I go to work, and
Okay.
but it's working really.
Okay. What if I give you a date, a few weeks out, even a month out, that would allow the two of you to work together and present a proposed parenting plan to me that mirrors what the both of you are comfortable with right now? That would be really helpful to the court. And I think it would give the two of you a little more legal basis for the situation. Right now, if you're operating outside the court's orders, certainly Ms. Fleischman could change her mind at any time and say that you're in violation of the court orders. We want to avoid that. So there are forms called parenting plan, and there's a box you check saying temporary or final. You can work, if you're still in contact with Christina Day, the GAL at all, she can kind of talk to you about that as well. How much time would you want for you and Ms. Fleischman to work on something like that and get it back in front of me?
So I have this next month is going to be I'm leaving the state for 3 weeks.
Okay. So do you want to do like mid-September, like September 20th?
If it's not an inconvenience for the court, I would appreciate it.
You don't have any pressing deadlines. So I'm really working on whatever schedule works best for the two of you. So let's set you for September 20 at 9 a.m. Please make sure Ms. Fleischman knows.
Yeah.
And then, like I said, if it's an agreed parenting plan, please present that jointly. If the two of you have a few sticking points you want the court to decide, that's fine too. We can kind of talk through those things when you're back on September 20th.
We were talking, and if we were thinking that if things keep going the way they are now, up until the beginning of 2024, then we probably just end the parenting plan and just, that was kind of like between me and her. That's what we're shooting for, as long as we don't have any hiccups in between then. And because things are just really good right now. Just,
Yeah. So, and certainly I can't give you legal advice or tell you what to do in that situation, except that, if there's a history of when things haven't been going so great, sometimes it's good while you are working together to get something finalized in place that maybe when people aren't working so well together, they have something to say, hey, this is what we agreed to, so that you don't have these ups and downs where, years you have to be in court and years you don't have to be in court. So, but yep, we'll set you for September 20th, and then you two can let me know what you want to do at that time.
Okay.
Okay. All right. And just so you know, Ms. Call, when Ms. Emerson, excuse me, not Rooney anymore. Ms. Emerson, can you hear the court?
Yes, I can.
Okay. Apologies for using the incorrect last name.
Oh, no, thank you so much for correcting that.
Mr. Rooney, are you present with us?
Yes, I am, Your Honor.
So Ms. Rooney had initially let the court know that she is thinking she wants attorney representation on this case. So she is asking essentially for nothing to proceed forward today and kind of set new dates. My understanding is we were going to be here today just to look at the final GAL report, perhaps talk about visitation, but it sounds like she would like representation before we do that. What is your thought, Ms. Call?
I'm not surprised that she would like representation for that.
And we can't hear you too well.
I'm sorry. I wonder. I heard this in the other courtroom too. I'm not sure what's changed. I need to check.
Once you're a little bit closer, it is a little bit better.
Thank you. I stand by my report. I stand by my recommendation. I feel like we've done a pretty thorough investigation. I know Ms. Emerson. I have not yet received, not because of anything she's done. I just have not yet received the results of her psych evaluation or actually I did receive the results from her. And so it could be that that's something too that would be important. Both parties waited until very, very late to have those things scheduled. So the report was filed before those results were into me. And I wanted to make sure we got the report in on time because we've had several extensions on this case. So I have not yet seen, to be fair to Ms. Emerson, I have not yet seen the results of her psychiatric evaluation. And her hair follicle was negative for all substances. So, I can appreciate why she would want representation going forward. I wouldn't have any objection to that. If Your Honor would like to go through the report, I'm certainly available to do so.
Okay. And Mr. Rooney, thank you, Ms. Call. Mr. Rooney, there's been a request, I think, by Ms. Emerson to essentially continue this matter for 2 weeks as she is trying to seek legal counsel. Do you have an objection to that?
Yes, Your Honor, I do have an objection. This was supposed to be the guardian litem's final report. And I feel that we shouldn't have to keep processing and going through if she wants to wait last minute. We've been in court since February. She's had the last 6 months to reach out for legal aid. I think that if she wants to reach out for counsel, then it should be on her own time. It shouldn't affect me with more court dates and putting this off longer.
Okay. Here's going to be my ruling. I think in a situation where potentially at stake or, you know, the type of parental restrictions that we are talking about in this case, I'm going to err on the side of caution and grant just a brief continuance even to review the GAL reports. The reason is if there is counsel, this will get set to a different attorney represented docket. So it'd be a different judicial officer anyway. I'd rather not have Ms. Call have to go through that twice and potentially end up with conflicting judicial opinions on a report. Also, I'm not anticipating offering a lengthy set over here. I do take Mr. Rooney's comments to heart that this has been going on for quite some time. I understand that more recently, perhaps for Ms. Emerson, the stakes have gotten a little more serious, and perhaps that's why attorney representation is being requested. But I don't want to stand in the way of Ms. Emerson making that attempt for representation, should she choose to do so. What I'll do is I'll set this over 2 weeks, if that date works for all the parties on this docket. And what that means is by doing that, it would be August 16th. Does that work for the parties?
I have another case in Clark County that morning, Your Honor. If we were farther down the docket, I could do a juggle again.
Okay. I hate to do that to you so many times in a row. We'll try not to make that a habit on your cases.
Excuse me, Your Honor. I'm sorry. I do have an appointment on the 17th.
What type of appointment?
It's a legal aid.
Okay. Well, here's what
my time frame was a little messed up.
Okay.
That is.
What about August? What about August 23rd? That's 3 weeks, and that's about as far as I'm going to offer.
That will work for me.
Okay. Mr. Rooney, are you available August 23rd at 9 a.m.?
Yes, Your Honor. I would also like to make a suggestion if possible.
Go ahead.
I feel that the hair follicle test that was done needs to be a longer one because In Town only offers 3 months, and I feel that she waited for her hair follicle test to do it, waited 3 months to do it, so that if there was anything in her system, it would be cleared. I would prefer the year test to prove that she hasn't had anything in her system in the last year.
Ms. Call, any input on that?
I would support that request. There's been some reports regarding things that she put on social media. We know that there was a very serious incident with the police and domestic violence in which she was very, very intoxicated and not communicating with the officers. So I would support a request for a hair follicle that reaches back farther than 3 months.
Okay. Are those readily available through the same agencies, or I'm just trying to figure out how to specify that in an order?
I would have to do a little research on that, Your Honor. I don't know the answer to that. I know most of our tests come in through Omega, so we'd have to kind of reach back to where those are originating from and see if I can get the information.
Okay. Yeah, why don't we do this? I'll reserve ruling on I think you were asking for a 12-month hair follicle. Let me reserve ruling on that. I'm leaning towards granting it. I just want some specifics on, so that we don't set Ms. Emerson up for failure, kind of specifics on where she can get that done and that sort of thing. So, Mr. Rooney, thank you for bringing that up. We can readdress that on August 23rd at 9 a.m. if we haven't come up with something sooner. And then I'm going to issue a bench order just to make it clear, because I think our last bench order was that we were amending visitation on an emergency basis, and it would last through the date of our next hearing. So I'm just going to make it clear in this bench order that my restrictions, my emergency restrictions from June 29th will continue through at least August 23rd when we come back here and issue any further orders.
Excuse me, Your Honor. As for the phone call visitations, I was having quite a bit of trouble with the app when I first got it. I had made a whole account and everything, and then I was not able to receive my information. It wouldn't let me log in. It would force close. I finally got that all figured out. And then I had messaged, I'm still trying to learn the app.
Okay.
I had messaged, I'm sorry. I had messaged customer service asking about how to do phone calls, and they had emailed back saying that they currently did not offer that. So I forwarded that email to Ms. Call.
Okay.
And then I believe it was about a week or two later, Mr. Rooney was saying that there was a way to do it on the app. I have yet to find out. I contacted customer service and everything, and still have not heard back from them. So I was just wondering, what would your recommendations, or what would be okay forms with you to communicate with my daughter?
I can't solve people's tech issues. Unfortunately, I wish I could. I'm going to leave my order in place that allows electronic and video messaging to be coordinated through our family wizard, unless Ms. Call has a better suggestion for me.
Yeah, so my suggestion would be there's a calendar in the app that you can go in and schedule your visit. And so through the messaging portion of the app, if Ms. Emerson and Mr. Rooney can agree on dates, or Ms. Emerson can go into that calendar and say, here are the times I'm going to call, or here's when I'm available to call. And they can communicate through the messaging portion of the app and calendar those things there. My suggestion, Your Honor, would be that she be able to make those calls via things like Zoom or Google Meet, or just a phone call.
Okay.
Want to interfere with digital communication. I think any of those platforms would be fine, but using that app to communicate is just so much better than having them texting each other. It removes a lot, like I said, all that communication is recorded, and the calendar element of that app allows them to schedule these things without having to have too much conversation about it.
Okay. Mr. Rooney, are you comfortable if the modified video allowance would essentially say that the two of you would be using our family wizard to coordinate the call times, but that other platforms like Zoom, FaceTime, Google Meets, phone call would work as well for the actual communication?
So my only issue with that would be I work Mondays and Thursdays, which are the call times, Thursday at 4:00 and then Monday at 5:00 because my daughter's in counseling. And my grandma only has a flip phone, so she's not able to do FaceTime. I have allowed 2 phone calls to my grandma's phone with it on speakerphone and my grandma sitting there supervising it.
Well, so it sounds like then it would be, we could leave it as Zoom and FaceTime are allowed, those sorts of video calls, but that really just an old-fashioned phone call is also allowed, and probably the only thing that's going to work given the call schedule.
Yes, Your Honor.
Okay. What I would just recommend, and again, we can read, this is short-term through August 23rd when we make some more final recommendations about what this situation looks like. But for now, that's what I will put in my bench order. And that's what I'll expect the parties to go off of. And then we can readdress any issues with that. I would just encourage Mr. Rooney, if there are times that you're available to allow that video time with mom and kiddo, that probably is important every so often. I'm not going to require you to do it every time because it sounds like that won't work with your work schedule, but that is important given, how this case has gone. And I think it's a safe way for the two of them to just see each other every now and then.
And Your Honor, I'd like to note something else as well.
Okay, well, I'm running out of time with your case. Is it an issue that's in front of this case, or can we discuss it on August 23rd?
It's about the recent missed visitations with her.
Okay, why don't you document that with Ms. Call? We can talk about it on the 23rd when we're going through the GAL recommendations, okay?
All right, sounds great.
All
Yes,
right,
Your Honor.
thank you all. Okay,
I'm
you're free to
also
log
here.
off. And this is Molly Watson?
Yes.
Okay, are either of you able to turn on a camera?
Yeah. Let me.
Yes, Your Honor. Got my camera on.
Okay.
Yes.
All right.
I sent you a direct message, but I know you're pretty busy.
Are you talking to the court?
Yeah.
I don't have.
Oh, wait, did I? Oh, I might have sent it to the wrong person.
Okay, I don't have any messages.
Yeah, that's okay.
Okay. Okay, and we have Ms. Looney here on this matter. I'm just kind of looking at the history from when you were back in front of, I believe, Commissioner Baldwin.
Your Honor, if I may, I just have a procedural question on this case. This is an odd numbered cause number, which is typically heard on the Thursday self-represented docket. So I'm just checking in to see if it'll continue to be heard on Wednesdays or if it will be moving to Thursdays, simply because our office divides our caseload based on which date or day of the week they're being heard.
Oh, right. I see that. And this would typically be Ms. Powers' case. Is that right?
Yes, Your Honor.
Yeah, I see. And she was present for the last one. I wonder why wonder why we switched it. Okay. Well, I do think that this would, unless was from Ms. Watson and Mr. Watson, was there a reason that you had asked to have this on a Tuesday docket instead of a Thursday docket?
This was the day we were given.
It was just the date you were given. Okay.
Yeah.
Okay. That might have just been a oversight on our end here. So I think we'll get you set back to Thursdays from now on so that Ms. Powers, who's the state's attorney with the history of this case, will be involved. I'm not saying Ms. Looney doesn't have the history and is not perfectly capable, but I know that's how they divide up work within their office. For now, so I think I will, as far as the actual orders, get you guys scheduled on a Thursday date because that will be a different judicial officer. But let me see if I can help with it looks like there was a mediation center issue. Tell me what's going on there.
I don't think there's an issue. I messaged them. I'm assuming Josh also paid his portion. I had paid my portion. I messaged, I believe her name is Miss Moore. I think she's the mediation manager. She said she won't be in office until the 7th. And so I think that's just what we're waiting for to get scheduled.
Okay. And then it looks like, Ms. Watson, you have presented an order to me to officially transfer the case to mandatory mediation. Is that right?
Yes.
Okay. Ms. Looney, just based on your review of this case, any position on this going into mediation before orders are signed?
No, Your Honor. We would be in support of that. We've got proposed worksheets ready. So if there's an agreement reached, we would be prepared to do child support.
Okay, great. Mr. Watson, what is your position on mediation?
I did the application and paid for this morning, and that's where I lie on that right at the moment.
Sorry, I think we're having a bandwidth issue. Just go ahead and turn off your camera. That'll help the audio.
All right. I did my application and got it sent in and did make my payment on it today.
Okay.
So I'm just waiting to get a date scheduled. I wanted to see what was going on today before I emailed her.
Okay. And so typically, and you cut out again, so I'm just going to keep moving forward. Typically, we would order 50% of mediation paid by each party. Are you both in agreement with that?
Yeah, we both, I'm assuming he paid and I also paid.
Okay.
Yeah, we're just waiting to be scheduled. Like I said, she said she'll be back in office August 7th. So I'll go ahead and send her another message about scheduling.
Okay. So then let's get you a review date a little ways out on our Thursday docket after we think mediation might occur.
Okay.
And I'll tell you, I think when I did this docket last week, Well, no, that was just with the courthouse facilitators. I don't know the mediation schedule. I would say to be safe, probably, and you guys could always renote it on early if you do get mediation and it's successful. But if she's not back till the 7th, let's let her have August to get you all scheduled. I would propose either September 13 or we're looking at Thursday, September 14 or September 21.
Any of those is fine for me.
And do I have that right? It would be on the Thursday?
Yes.
Okay. Mr. Watson, any preference?
No, I mean, you said the 14th.
14th or the 21st?
Let's go ahead and do the 14th.
Okay. So let's set you on for review of mediation status. You all did present some orders that'll track to your next docket. But what I'll say is if in mediation, you all come up with different proposed orders, please file those with the court before the September 14th date. Okay.
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 And this will be also 9 a.m.
Also 9 a.m. Also
Okay.
by Zoom.
Okay.
Okay.
All right. Very well.
All right. Thank you both. In front of me
Thank you.
is a proposed parenting plan by you, Ms. Johnson. And Mr. Perkins, you also prepared a proposed parenting plan. And Mr. Perkins also is proposing a restraining order, it appears.
Your Honor, I've decided that I'd like to strike that restraining order at this time.
Sorry, just you kind of cut out there. You're free to turn off your video if that helps with your bandwidth. You're striking the request for the restraining order. Did you say you're striking?
Yes,
Okay.
Yes, I'm striking the restraining order proposal.
Okay. So then what I have in front of me are proposed temporary orders filed by the two of you. Have you all had a chance to see what the other person is proposing?
Yes, Your Honor, I have.
Okay. Have you all been able to find rooms of agreement, or are we essentially at a stalemate and you want the court to decide?
Well, I was under the impression that we were under an agreement. We've been in court before. And then with her response to my recent parenting plan, she has changed her requests yet again. So I honestly do not know where we stand at this moment.
Okay. And then is there still, I know initially when this was filed, there was an attorney present. Are there any attorneys on this matter currently?
No, Your Honor, not on my end.
Okay. I'm just going back to look at the history again. I'm just jumping onto your case. I want to make sure I understand the history of where you've been. I do see, looked like back in April of 2023, it seemed like you all were close to agreement on the parenting plan. Then I'm guessing things fell apart because I don't have any filings then until July 14th. And this is what,
yes.
Okay.
Yes, that I had representation through a lawyer for about 3 months. I've worked on various parenting plans with Mrs. Johnson, and she had changed her mind at the last minute on all of them. The last one, she actually came up with the plan with me and had signed it, and then changed her mind just before the judge was getting ready to sign it.
The only thing I changed my mind on was the 50-50 for the daycare costs. And I was requesting to get daycare with my son instead of paying for daycare. That was the only thing that I had not agreed on.
So, and probably I'm wondering if the answer is no, because you all had an attorney involved and were close to a resolution. Have you all ever had a guardian ad litem on your case?
No.
No, Your Honor.
And I'll tell you what kind of clues me in that might be something that's necessary. It's, at least in Mr. Perkins' proposals, there's allegations that he's asking the court to find abandonment, neglect, emotional or physical harm, lack of emotional ties, abusive use of conflict, withholding the child. And then when I switched to Ms. Johnson's request, she doesn't include any of those neglect, abandonment, abuse issues, but she alleges that there's withholding of the child by father. So my concern here is in these types of situations, we would typically at the court's request, appoint a guardian ad litem that would meet with the two of you, any other potential figures in the child's life, speak to the child and make a recommendation to the court, number one, about whether any of those limiting factors like abuse and neglect are present, and would then make a recommendation to the court regarding the parenting plan. So I think because you all have not gone through that process, that my ruling today will be to appoint a GAL to your case. The names: Keith Lawrence, Heather Kale, Amy Turnbull. Do you have an objection to any of those names?
No, Your Honor.
No, Your Honor, I have no objections.
Okay, so then we will assign Keith Lawrence, since he is next on our list. And let me do, are either of you receiving state assistance? And I'm asking this question to see whether you all will be paying a part of this GAL report or whether it will be county pay. So Ms. Johnson, first for you, do you receive any state benefits?
Just medical insurance.
Okay. What is your monthly income, just approximately, before taxes?
I don't have any monthly income right now.
Are you not working?
No, Your Honor.
Okay. Okay. And then Mr. Perkins, are you on any sort of state benefits?
No, Your Honor.
Okay. What's your approximate monthly income?
Approximately $7,500 a month.
Okay. And then do you have other dependents you care for with that monthly income other than the kiddo in this case?
No, Your Honor.
Okay. Okay. So what I'm going to make a finding, since you're, sir, kind of significantly above the, what we would call the poverty guidelines for allowing the county to pay for this, it's going to be, we're going to do Ms. Johnson, your percentage will be covered at county pay. And then Mr. Perkins, and especially since you're the one with the allegations of abuse and neglect that really trigger me to request this report, we'll do 30% at county pay. And then 70% of this, sir, will be paid by you as the petitioner. Okay. And then this guardian ad litem will be in meeting with both of you. So if you get phone calls from Mr. Lawrence, please respond to them quickly. We're going to set our first 30-day review date, August 30th at 9 a.m. for our first review date. Let's do September 23rd for the next review date. And then I think the final report, just grab my calculator. Let's set December 6th. Well, let's go 1 week earlier because that's 126 days. So it's going to change from December 6th to November 29. All right, I will get that order filed, and then we'll see you back on August 30th for our.
Your Honor.
Go ahead.
As far as seeing Clayton, am I allowed to get some kind of a temporary parenting plan in place with Mr. Perkins so I can see Clayton? Because right now he's not allowing me to see him.
So Mr. Perkins, what's going on? And I'll just say, we're not entering orders until we have some guardian ad litem input. So Mr. Perkins, you should not be withholding child at this point.
Every chance or every opportunity that I've given her to see Clayton, she has kept him longer than
Your Honor.
She is supposed to. This last time was over a week. She has indicated to me that she plans on moving hours and hundreds of miles away here soon. And so I am keeping Clayton in my care because I am not comfortable with him being in her care for extended periods of time. And she's recently, well, through this whole process, has been deceiving in when she is going to return him, when she's going to take him, and just her unstableness as of late has caused my concern.
What's the current visitation?
We had agreed on every other weekend, and like I said, this last time she took him, and then when it was, I had messaged her numerous times on multiple days and with no response, and then that is when I filed this most recent parenting plan with the restraining order. This was an emergency decision to try and get something on file so I have some legal recourse to get my son back.
The only proposals in front of me are, if you are not actively on this call, please mute. The orders in front of me, Mr. Perkins, that you submitted, I just can't sign. I mean, you essentially, without evidence presented to this court, are asking for supervised visitation only, no contact other than with someone else present. I don't have enough information in front of me to warrant that kind of restriction on Ms. Johnson's parenting, when in fact, I kind of look at the history of this and you all were so close to an agreement. This does seem to be a 180 from where you previously were. So if you want the court to reconsider a temporary parenting plan pending the GAL involvement, and who will advise this court, then you would need to note back on this docket a more reasonable parenting plan. I started going through it to see if I could come up with some compromises just as an interim parenting plan. And Mr. Perkins, your order just essentially gives her no time at all. So I would really encourage you to go back to the drawing board and present something that's a little more workable for the parties.
Can I respond to what he was saying?
No, we're done with time on your docket. I've set your review dates. We'll see you back on August 30th. If you folks want to renote a temporary parenting plan that is reasonable and supported by the evidence before August 30th, please feel free to do so, but I can't sign what's been submitted to me. So I have thank you both. We'll see you back. Order and motion for contempt that Ms. Johnson, you are filing alleging past due child support from 2017 to 2023. And I'll just state the difficulty I'm having. I'm assuming that there is some past child support that hasn't been paid, but I can't go off of vague assertions between, for essentially a 6-year period that some child support hasn't been paid. Let me go back and look. I'm not seeing actual financial documents that allow me to come up with the exact amount that you're requesting. I guess what I'm saying is I cannot tell what the basis for this number is. So Ms. Johnson, I'll open it up to you to let me know, since you filed the motion, what you're relying on.
This is the first time I've ever filed a contempt, so I wasn't entirely sure on, what I was filling out, what to do. I got some pointers from the clerks. I guess, so he has paid child support in the past. It's just been so inconsistent for our son. And now he's about 7,200 in arrears. And I just want some accountability on his end. I don't know exactly what I'm asking for. Maybe just someone to push him to pay what he's supposed to pay every month. Just so it's not just such a financial hardship on our son.
Well, again, there's really nothing specific I could order without any factual basis to support the amount you're requesting, meaning I don't know what dates specifically have remained unpaid, and it just vaguely states he's paid some, but not all. Mr. Ryan, let me turn it over to you. Can you hear the court? If you're on a phone, you need to unmute using *6. Ms. Johnson, here's where the court's at. I can't get any audio from Mr. Ryan. I would just say, based on the face of the pleadings and the lack of any evidence you've submitted to me, I don't have any basis to order contempt at this amount or any amount. I'm going to deny your order without prejudice.
Okay.
Which means that you can refile this order with additional documentation and bring it back in front of the court at any time. You would just need to renote it for a Wednesday 9 a.m. docket. And if you do renote it, we would just need some more specifics on what really the factual basis for your order. Okay.
Okay. I did have a question.
I might be able to answer it. I can't give legal advice.
Okay. There was another part of the contempt that I had filed regarding inappropriate things that my son was drawing.
Yeah, I see that. And you did file that. So you're alleging, I did see that. And you're alleging that there's clear stipulations in your parenting plan stating there shouldn't be inappropriate movies, games, etc.
Yes.
Hello. Hello. Hello.
Oh, there you are, Mr. Ryan. Hold on. Ms. Johnson, I'm asking you a question.
Oh, I had answered it. It froze up on me.
Okay.
But yeah, there are clear stipulations regarding inappropriate games, movies, anything. And now our son told his counselor what he has seen at his dad's house.
Mr. Ryan, now that we do have you, do you want to respond?
Yeah, I've faced several allegations from several states. I've dealt with Child Protective Service in Washington and Oregon and Sheriff's Office in both states, and I've been cleared by both, and I've been deemed to have done nothing inappropriate with my son at any point. He was watching horror movies and stuff. It's been well over a year, and we've had documented issues with it. We discourage that greatly. We're trying to get him more online with, he likes monsters and stuff, so we're trying to do more kid-appropriate stuff. It's been a process, but we're not, as much as I've dealt with, I don't do anything to encourage anything that's going to cause me to not be able to see my child anymore. Yeah. I'm back living with my mom, and she's there all the time, and she can attest to that. I'd read the report too, and something about maybe he'd seen inappropriate behavior with me and another adult, and that also didn't happen. Like I said, I'm staying at my mom's, and I haven't had a friend over. We've been very careful about what we watch and listen to when he's here. And like I said, I'm really trying to encourage him to steer himself more towards age appropriate things. We're trying to get him more on, like, Roblox and the same stuff everybody else is into. Mm-hmm. It has been a process, though.
Yeah, I guess again, I kind of go back to, well, let me ask first, are both parties and kiddo residing in Washington now?
No, ma'am. I live in Oregon.
You are in Oregon, and where is kiddo predominantly residing?
He's with his mom most of the time.
And ma'am, are you in Washington?
Yes, I am in Washington.
Okay. Okay. Yeah, I'm going to stick with my decision based on what has been filed in front of me. Don't think there's enough for me to issue contempt on this. But again, it is without prejudice, ma'am, if you want to refile with additional documentation. I would say I do take to heart what Ms. Perkins states, that because he is, or excuse me, Mr. Ryan states, because he is an Oregon resident, there is perhaps Oregon child support that's gone through the state of Oregon. Before I would issue any contempt, I would want clarification on which state is collecting.
Also,
well, this
I was.
okay, we're past our docket end time. I've made my ruling. If Ms. Johnson wants to bring this motion back, please do so with additional documentation. Okay.
Yes, ma'am.
Thank you.
Thank you.
Thank you.
Thank you.